channel Judicial Study. In this video, we just cover an article of Jurisprudence, article of N.R. Madhava Menon. That article can cover the uh, about our legal system of jurisprudence. We'll just cover the components of legal system. Let's guide move ahead. Before move ahead, please subscribe this channel and press the bell icon to get notification on time. You can also join my Telegram channel or Telegram group, namely same as YouTube channel Rahul Print Study. I will share the PDF in that platform. So guys, move ahead. Let's start the reading. Please open your casemate for better understanding of jurisprudence. Page number, it's page number 1. Okay. Our legal system. N.R. Madhava Menon article. The legal system of a country is a part of its social system and reflects the social, political, and cultural characteristics of the society. It is therefore difficult to understand the legal system outside the socio-cultural milieu in which it operates. It is true in the case of India. Also, even though the legal system we now have is largely the gift of the British rulers, there is a view that the system is still alien to the majority of Indians whose legal culture is more indigenous and whose contact with the formal legal system. The important British model is marginal, if not altogether non-existent. The language technicality and the procedure of the inherent legal system are indeed factor which limit access to justice for the illiterate, impoverished masses of our country. Nevertheless, the rights and benefits conferred by the laws and the constitution offer the opportunity for those very people to enjoy the fruits of a welfare democracy, which will people of India have given unto themselves on the 26th January 1950. On this date, our in a democratic India republic became a republic. It is in this context familiarity with the law and its process becomes essential to every Indian, rich or poor, man or woman, young or old. The component of legal system. A legal system consists of certain basic principles and values largely outlined by the Constitution. A set of operational norms including rights and duties of a citizen spelled out in laws centrals, state law, local institutional structures for the enforcement of the laws, and the career of legal personnel endowed with the responsibility of administering the system. Administering the system. The Constitution, the fundamental law and of the land. The Constitution is regarded as fundamental law of the land. The constitution of a country variously described depending upon the nature of the policy and the aspiration of the people in a given society. It is generally a written documents and assumes a character of federal, several independent units joined together or unitary forms of government. India is declared to be a socialist, secular, democratic republic as is mentioned in the preamble of our constitution. It is said to have a quasi-federal according to by the Akashu era. The Constitution of India represents the collective will of 700 million Indians, and as such, the reservoir of enormous power. It describes the method by which this power conferred on the state is to be exercised for the benefit of the people. In the other words, it is a politically document which distributes state power among different organs, central and state governments, legislative, executive, and judicial. There are three state governments wing, namely legislative, executive, judicial wing of each government, and regulates its exercise in its incident on the people. The form of government is democratic and republican, and the method is parliamentary through adult franchise, that is 18 years old. Uh, the goals are spelled out in the preamble itself, which seeks to secure to all citizens justice, social, economic, and political liberty of thought expression, faith and worship, equality of status and of opportunity, and to promote among them all. Fraternity assuring dignity of individual and the unity integrity of nation. To achieve this goal of dignity of individual with justice, liberty, equality, Constitution grants certain fundamental rights and provides for its enforcement. Though the High Court and the Supreme Court, this basis human right includes equality before law. These are the fundamental right. Equality before law, as Article 14, equality of opportunity in matters of public employment. 16. Prohibition of discrimination on grounds of relation, sex, etc. Is 15. Protection of life and personal liberty. 21. Protection of rights to freedom of speech, of assembly, of association, of movement, of possession or occupation. Article 19. Prohibition of forced labor covers 23, I guess. Freedom of religion for 24. Protection of interests of minorities and the right to constitutional remedy for enforcement of the right, that is covered under Article 32. Further, towards assuming the goal set out of the preamble of the Constitution, gives certain directives to a state to follow in its policies and programs. Principles of the state price policy have been recognized to be as the sacrosanct as fundamental rights. In other words, they together constitute a reference for the state action in every sphere. The Constitution emphasizes a unique place for the judiciary, apart from overseeing the exercise of the state power by the executive and legislature of the state, and the central government, the Supreme Court, and the High Court are charged with the responsibility of the effectively protecting citizens' right through its writs jurisdiction. There are five writs will cover. Then other topic of constitution. This offers a cheap and the expeditious remedy to the citizen to enforce the granted right. The Supreme Court liberalized the rules so as to enable poor and illiterate citizens to have easy access to the court and for the enforcing their basic right. The rule of law is supreme, and the independence of judiciary is reality in our country. This forms the bulwark of the democracy. Compels everyone to abide the law in his own be the understood and subscribe to be every Indian if we are succeed in our declared goals. Now, laws civil and criminal. The laws of the country are too numerous, varied, and complex. They are bound to be so because law is a large and life itself, which is increasingly becomes complex in every sphere in a fair state like ours, India. Laws are at the more so because they are expected to regulate a variety of social and economic activities so as to subserve the common good. Inspired by the constituent parliament, the state legislature, and the local councils make and unmake the laws. Laws day in day out the as occasion demand, courts interpret them in the specific fact situation and in the process extend the scope and application of the land laws. The common man may get lost in the maze of legislations coming from all sides and contribute to its complexity by the creating his own laws through contracts and agreements with others. He has to deal with on the basis of the remedies sought and the procedure followed. All laws can be grouped into two categories, namely civil laws, criminal laws. Broadly speaking, criminal laws is concerned with the wrong against the community as a whole, while the civil law is related to the rights, duty, and obligations of individual members of a community between themselves. Civil law includes a number of aspects which may be grouped under six or seven major headings, such as family law, the law of property, the law of tort, the law of contract, the law of relating to commerce and business, labor law, law of taxation, etc. Family law, which in India has its source both on the statutes and religion, comprises of the law governing marriage, divorce, maintenance, custody of children, adoption, inheritance, and succession. Thought the Constitution emphasizes a uniform civil code covers in Article 44 of Indian Constitution. Each religious group, please comment where the uniform civil code has exercised till now. Uh, please give the state name of India. Each religious group at the present follows largely its own norms, its matrimonial and family relations. The law of property includes rights of ownership, transfer, mortgages, trusts, intestacy, and similar matters. The law of contracts is concerned with the enforcement of obligations arising from the agreement and promises. This includes the transactions such as sale of goods, loans of money, partnership, insurance, guarantee, negotiable, negotiable instrument, agency, and the like. The law of torts deals with the propriety of action and infraction of duties. Injuries to person or property caused by failure to take reasonable care and caution leads to actionable wrong under tort, which usually compensate the victim of such injuries. Laws of commerce and business, which includes contract law, led to economic operations of individual partnership and companies and governmental regulation of them. Even law of taxation forms part of commercial laws. Labor law deals with the relationship between employer and employees in production and distribution of wealth. Uh, Criminal law is concerned with the public wrongs or wrongs against the order and well-being of the society in general. The person guilty of such wrongs are prosecuted and punished by the state. These wrongs are specific and are defined in penal code. A few other special and local laws. One important aspect in this regard it is that criminal laws insist, apart from a few exceptional offences, on a particular intent on a state of mind as a necessary ingredient of criminal offence. I also recognizes a degree of criminality and gradation of crime. Ignorance of law is never taken as excuse. The term ignorancia of law is not excused. The certain situation where the guilty intention could not have been entertained, such as infancy, insanity, mistake of fact, etc. They are recognized as the defense to criminal responsibility. Offences are classified on the basis of objective or otherwise. Thus, there are crimes against the human body, property, reputation of the individual, against the state, or the against public rights. Okay, on the procedural basis, they are the classified as the cognizable or and non-cognizable. Cognizable are those in which police can investigate or arrest a person without judicial warrant. Bailable and non-bailable, compoundable or otherwise. Okay. Now we talk about the procedural law, civil and criminal. Most of the proceedings in the Supreme Court and the High Courts are governed by rules of procedure made by the courts themselves under the power given by the statutes. The Civil and the Criminal Procedure Code and Evidence Act do apply to judicial proceedings in this court as well as the writ procedure under the Article 32 and 226 is unique to the court related to the under the article 32. The Supreme Court can issue the writ against the individual for protection their fundamental rights, and under article 226 the high court also uh, issue the writ against the protection of the individual as well as for other uh, uh, rights. And is the in the writ in writ jurisdiction, the jurisdiction of the High Court is wider than the Supreme Court, intended for the quick enforcement of the fundamental rights whenever they are threatened by the state or its agencies. In such situations, citizens can approach these courts even though through the letter sent by post as the component as the Supreme Court has declared that the procedure should not be allowed to come in the way of the dispensation of justice. For the enforcement of the civil rights and obligation, a suit before a civil court is usually instituted. The procedure of trial and appeal, including the execution of the decree and orders, are laid down in the Code of Civil Procedure. Variationism for purpose of jurisdiction is made according to the Suits Valuation Act. The amount of the court's fees to be paid on the plaints and the appeals is determined by the Court Fees Act. The Limitation Act prescribed the periods of limitation which suits can be filed. The Evidence Act regulates the relevancy, admissibility, and the probative value of evidence laid in courts, civil and criminal. The trial is in the nature of the adversary proceeding where two parties oppose each other in a suit or action between parties. The procedure commences with the pleading, which set out the precise question in dispute or cause of action. The opposite party, the defendant, may file a written statement to admit or deny the allegations in the plaint. The, the pleadings may be supplemented by the parties by making admissions of fact, answers, and the interrogatories oral statement before the court, and by admissions and denials of the documents filed by them. The hearing of a suit commences with a serving of the copy of the plaint to the defendant. A party can appeal himself in the court for the hearing or mistake appearance, though an agent or a pleader, according to the Advocates Act, right to practice law before courts is given to the advocates only. In the proceedings, party have to summon their witness for deposing in court. The trial involves recording of evidence with witnesses on a day-to-day basis, at the conclusion of which judgment is to be pronounced in open court. Because civil proceedings are private matters, they can at any time be abandoned or compromised, and in fact in number of cases they are settled before trial. Judgments are enforceable through the authority of the court. Refusal to obey a judgment may lead to penal consequences. Many decrees are open to appeal in higher court within the specified period. Criminal procedure are governed by the provisions of Code of Criminal Procedure, the purpose of which is to determine whether the cause accused is guilty of the offence charged, and if so, to decide the punishment to be awarded. Therefore, it is designed to give every accused a fair trial, consistent with the constitutional commitment to individual liberty and freedom. A criminal proceeding involves four major stages, namely investigation, prosecution, trial, and disposition. Mark this line, guys. This is important line. The criminal proceeding involves four major stages, namely investigation, prosecution, trial, and deposition. Crimes being wrong against the society and the state undertakes the prosecution on the behalf of the victims. The police, on the receiving information of the commission of an offence, proceeds with the investigation. They are authorized to interrogate people, arrest and suspect with warrant from the magistrate in non-cognizable cases. Search place for the recovery of the relevant material, seize property connects with the crime, and prepare a report on their finding of the necessary action by the prosecution authorities. Whenever the arrests are made, they are obliged to produce the arrest person before the nearest magistrate within 24 hours. They are not to use third degree method in the interrogation, and the confession given to police is not admissible as evidence in the court. In all available cases, they are bound to release the person on the bail. The arrest person has right to seek the aid of a lawyer of his choice, and he cannot be compelled to give evidence against himself. These are under the provision of the fundamental right of the constitution. You can go through that, guys. Under our law, every accused is presumed innocent, and the prosecution, the state has to prove the guilt beyond the reasonable doubt. If there is any doubt in the evidence or the prosecution, the benefit of the doubt is given to accused and is acquitted. The defendant has the right to cross the examine every prosecution witness, while he cannot himself be questioned unless he consent to be sworn as a witness in his own defense. In the case of indigent person, there is provision for legal aid and at the state expense. If at the end of trial the judge finds him guilty, he has a right to be heard on the determination of sentence. The emphasis in modern criminal justice being information and the rehabilitation, there is enough scope of the deserving convict to get correctional treatment as a part of the sentence. Apart from the civil criminal procedure prescribed in the respective codes, there are a variety of adjudicate procedure allowed flowed in the tribunals, quasi-judicial administration agency, arbitration council, Nyaya Panchayat, etc., where private disputes are processed and settled through the informal procedure. They are found to be cheap expeditions and less cumbersome in terms of adjudication. Okay, the legal aid has now assumed an important place in judicial procedure in country. Right to counsel by a lawyer of an own choice is a constitutional right every citizen possesses. In the case of poor person of criminal procedure code provides for the appointment of counsel at the state expense to defend the indigent accused in all major criminal cases. In civil proceeding, a poor person can declare himself to be a pauper, in which case he is exempted from co fees and a variety of related court expenses. Legal aid scheme set up in a state also provides such person with the service of lawyer to conduct litigation on their behalf. Court of law. Court are the institutions where the disputes are adjudicated and justice administered. They are created by the statutes and enjoy such power and jurisdiction which the statutes confer. The Constitution itself provides for the Supreme Court and the High Court in each state at the aspects of the judicial system and confers the original and affiliate jurisdiction on them primarily to resolve the dispute between union and the state and the citizen in limit cases appeal arising out of private dispute involving substantial questions of law. This higher judiciary is named as the Union Judiciary, and appointment to it are made by the President of Union on the advice of the Chief Justice. Citizen can directly approach to the High Court or the Supreme Court to seek the redress of the violation of fundamental rights. These courts have a supervisory function over the subordinate courts, state judiciary, which are set up each state according to its requirements under the Civil Procedure Code, Criminal Procedure Code, or the state laws. The High Courts and the Supreme Courts enjoy civil and criminal jurisdiction apart from the writ jurisdiction. Okay. The state judiciary under the High Court is organized in the hierarchy in the civil and the criminal sides based on their jurisdiction, territorial or the mandatory. On the criminal side, the Criminal Procedure Code provides for the magistrate court, first or second class, depending on the extent of the power for the punishment, and above them the session courts, usually one in each district. On the civil side, the Civil Procedure Code provides for the municip's court with the limits pecuniary jurisdiction. The subdivisional court and the district court, each with the varying pecuniary and territorial jurisdiction. There can be a special court set up for the categories of the dispute. Thus, there are the motor vehicle compensation tribunal, sale tax tribunal, etc. All of which are judicial body adjudicating a dispute in the area assigned to them. Appeals from these courts and tribunals usually lie to the high courts, and in the exceptional cases, a second appeal to the Supreme Court. The personal of the law administration of justice requires the cooperation not only of the parties and the judges but also of the officers of the court who include the advocates, the court staff, and the paralegal personnel who assist the lawyer and judges. All the judicial officers from the Supreme Court judge to the municip in all small taluka are the independent of the legislature and the executive. They are free to administer the law without the fear and favor, and they cannot be inferred with by any one, including the top functionary of the government. They have to power to punish those who commit contempt of the court or the disobey the their legitimate order. Article 127 regarding the contempt of the court, or 131, just cross check guys, of Supreme Court. Thus, the President, acting on the advice of the Cabinet and the Chief Justice of India, appoints the judge of the Supreme Court and the High Court. The Governor of the state appoints the judicial officer of the state. Similarly, on the advice of the state High Court or government, their salary and the service condition are determined by the law and cannot be charged to their disadvantage. Their removal from the service requires a special procedure and control. They are the judiciary reforms based on the higher judiciary. Lawyers and the bar. Lawyers are the key functionaries assisting the judge in the administration of the justice. They are the officers of the court and are constituted into the independent profession under the Act of the Parliament, the Advocate Act 1961. No others may practice before the court without the expert assistance of lawyer. On either side of the dispute, judges will find it difficult to find the truth on the disputes fact in issue and interpret the legal application to varied situations. That is why the legal profession is often referred to as a noble and a learned profession. There are at present approximately 2,30,000 advocates practicing in the various courts in the country. For the organizational purposes, they have formed themselves into associations. They are enrolled into the profession by the Bar Council created by the Parliament under the Advocates Acts. The Bar Councils at the state level and the central level consist of elect members of the profession who undertake the responsibility of not only the admitting new entrants but also the improving the quality of the legal service, particularly through the exercise of the disciplinary power over hearing members of the profession. Legal service to the poor is the one of the social obligation of every lawyer requires under the Bar Council rules of the profession's conduct. So guys, just we have covered the major component of our legal system, the introduction of legal system. In next part we'll cover the another article, namely uh, the major legal system in the world today of Rene David and John E.C. Bailey. There are three family law, namely Romano-Germanic family, and another one is common law family, and third one is the relationship, sorry, third one is the other family of socialist laws. These three families based article we will cover in next video. That's it for now guys. Thank you so much for watching this video. I will just come with the next video of the bare classmates provided by Delhi University for the LLB program of first semester. Thank you so much for watching this video. I hope you're enjoying with me. Thank you so much for being here. Take care. Bye bye. Have a nice day. Be safe guys.